90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we'll be talking about intellectual property, which means how to protect your ideas. And our special guest is Daniel A. Scola. Daniel, welcome to Law You Should Know.
Yeah, thank you, Ken. It's Hoffman and Barron, LLP.
Why is intellectual property so important to all potential entrepreneurs out there and people who already own some type of business?
Well, I think intellectual property touches people's lives in more ways than they recognize. And almost every day you'll come across either a patented process or a product or a trademark or some original creation or a trade secret, and you don't even realize how much intellectual property touches your lives. And people often say, I saw this idea on television. I came up with that idea 10 years ago. I should have done something about it. Well, apparently it was a good idea, and someone else did something about it. So I think it's just something people have to recognize, that it's ideas are very, very valuable, and many people have great ideas, and they don't do enough to protect it.
And we'll discuss what some of the things they should do to protect their ideas starting on day one. And you also hear it asked on Shark Tank frequently. Do you have a patent or a trademark or some other protection for your idea or your business model? Why is that so important to a shark or an entrepreneur appearing on Shark Tank?
That's a good question, Ken. I mean, the idea of a patent is to give the creator a limited monopoly on that idea that's patented. And as you know, if you have the right to keep people out, it's an exclusionary right. If you have the right to keep people out of your property area, think of it like this. Everybody knows real estate and they know what a fence is. Well, intellectual property allows you to keep people, patents in particularly, keep people from going onto your property without a license. It's illegal to cross that boundary.
And a license might be a fee or a toll for them entering your property that you're collecting.
That's correct.
And if you don't have that fence, they can just come on your property, perhaps claim ownership of it, and you can't. It's hard for you to kick them off, and you lose some of your rights.
You absolutely do, and now you're in a situation where great ideas are just taken by someone else who might even have a stronger ability to market it than you do.
And sometimes you see a name used by different types of businesses, perhaps in different settings. So can you claim, like we think of McDonald's hamburgers, but if you had McDonald's cleaning or some other use of the name, are you able to do that, or are you able to keep someone from using your name in a different context?
It's a good question. Normally, the trademarks are for indicating the source of the goods, right? So we associate, like, the trademark, let's say Tide, with detergent. And we say, well, we can buy Tide. We know there's a quality product there. We know the source is Procter & Gamble, and so forth and so on. So the identification of where it comes from is very important to the public because they want to be able to rely on that for the quality. Now, if I were to obtain a mark for Tide for, let's say, a car as opposed to a laundry detergent, that might be fine because I'm not indicating the source of a laundry detergent. I'm putting it on a product which is very different, goes into different channels, is not going to be confused, and the public won't get confused on it. And that's really the bellwether for determining whether there's an infringement or not, or whether you can get a registration or not. Trademarks are designed to really help the public, in addition to creating a right in the owner, it's to help the public, keep them safe and understand what they're buying. It's the real thing. So yeah, but now in some instances, when you have famous trademarks, it's very difficult to get that registration because the public associates that mark with so many things. Like, for example, the word Nike is famous, and Nike, they sell all kinds of merchandise, not just clothing that might have Nike on it, or the Yankees. And many of these trademark owners register it for all kinds of different products. So sometimes it's difficult to just say, well, I want this mark. I mean, there was a recent case that was up on appeal where, Aaron Judge's, I think Here Come the Judge was at issue, and this applicant wanted to get that. And of course, Aaron Judge's attorneys were successful in stopping him. And it wasn't even for products that Aaron Judge would make, but it was a famous enough mark that people thought that it would create a confusion. And so if it's going to create confusion with the public, you're not likely to get it. That's one of the things. It also can't be descriptive. And descriptive means, describe exactly what it does.
Now, another common thing we see on Shark Tank is some entrepreneur has invented some kind of unique tool. It could be a craft person or a firefighter. They invent a better can opener or better gear. Mm-hmm. And they also need to protect their idea, and especially if they think they're the first person to do that. What are some of the criteria for qualifying for a patent, or let's say a utility patent, and also for protecting that idea?
Yeah, that's a good question as well. There are three main criteria in order to get a patent. The first is it has to have some utility, and we're talking about utility patents. There is also something called a design patent, but the criteria is generally it has to be useful if it's going to be a utility patent. You can attribute use in most cases to things that you're going to make. I mean, very few things don't have some sort of use, right? So that's not a high bar to get over. The second one, it has to be novel. And by novel, that means it can't have been done exactly that way before. And the last one, which is really the toughest hurdle, is it can't be obvious in view of things that have been done similar to it. So oftentimes that's the hard one to get over.
And let's go back to the famous mousetrap. I mean, there are many different, let's say, unique types of mouse or rat or rodent trap out there. Yeah. So you would have to find a better way, a different way of making your mousetrap and show it's somewhat unique.
Absolutely. In fact, that saying this is a better improved mousetrap, that is really very applicable to obtaining patents, because the patent law is designed to promote the progress of science. So what they make you do is they make you disclose your idea so that if you get it patented, you disclose your idea properly and they'll give you that limited monopoly. But the idea is to let the public be able to build on that. So improvement patents face the issue of, what did I do to get myself distinguished from what's been done before? How did I overcome what they call prior art, which is what's been done before? What's the improvement? And is it enough to convince the examiner that it's not obvious to do this?
And sometimes these are negotiated out. There could be litigation about it. I mean, you and your firm are also involved in battles over this, either protecting the prior inventor or let's say the new inventor.
Absolutely. So there's, on the one side, if you procured the property for, let's say, the client, and you want to enforce it, that's something we actually get involved with quite a bit. Then you have to send a cease and desist, or you have to do some kind of a negotiation or file a lawsuit to enforce the rights of your client. On the other hand, you try to keep your client from walking on other people's properties, but sometimes it's difficult when they're walking on the line. People might think, well, you really did cross over, and in that case, we have to defend the client and hopefully prove that either the patent does not cover what they do, or the patent might be invalid for a variety of reasons.
And I just want to remind our listeners, and you mentioned it earlier, if you think your patent or your protections, whatever protections you have, are being infringed upon, it's very important you act quickly, either perhaps on your own, or perhaps with a firm, something like yours, with even a simple letter, so you're putting them on notice about it, so you're not sitting back and waiting till they've taken over the market, or perhaps dilute your rights to your protection.
Yeah, it's not good to sit on your rights. I mean, it is important sometimes to take action as strategically. The timing has to be right, but it's important to take action as soon as you can, if that's possible.
And, well, at least again, put them on notice with some type of letter, and
absolutely,
you're also filing your patent, trademark, copyright, whatever it is, so you're first in line to show you've previously protected that idea.
Absolutely, the patent system is designed to to give you the benefit of the priority date that you file your patent application on, and so you want to take advantage of everything the law has to give you. And one of them is let's enforce what we've ultimately get as soon as we can, because the patent lasts only a certain amount of time, and you don't want to wait until everything is expired and gone, and then you have more difficulty.
And you may have invested time and money in perfecting your idea. So once you've done that, you want to protect your idea as best you can.
Yeah, I mean, ideas are very valuable. People oftentimes don't think of that. They think, well, I mean, I was in the shower, I thought about this great idea. But I mean, the truth of the matter is, a lot of ideas that they recognize as being successful are only successful because they were good ideas to begin with, and people took action to make it happen.
And again, you're going to help someone sort that out, whether it's a new
Absolutely.
idea, whether it's a good idea, and what they can do on some basis to protect that idea.
Absolutely. I mean, you have to judge it against what's been done before, and that requires you to understand what they did, get a patent search, review the patent search, position it against the backdrop of that patent search in order to make the decision as to whether it's commercially reasonable to go forward, because the kind of protection you might get might be broad, it might be narrow, it might be somewhere in the middle. And then you have to say, well, what's the market look like? There's lots of considerations.
So I just want to remind our listeners, you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College. We're talking with Daniel A. Scola, and he is the managing partner of Hoffman Barron, an intellectual property law firm, and we're talking about protecting your ideas, whether you're a young entrepreneur, or a business person, a manufacturer, how you can protect your ideas and also keep others from stealing them. What are some newer areas of technology and confusion? We have some people coming up with, let's say, fakes in the fashion industry. If someone comes up with design for a dress or a hat or a sneaker or a better type of shoe, is that something they can protect and keep people from infringing?
Absolutely. I mean, the types of things that you can in fact protect from with patents, for example, is quite broad. I mean, the fashion industry, many design patents are filed on the fashion industry. I mean, there's some utility patents as well. It's so many facets of life are affected by the patents side of things, and in process of doing things, there are manufacturing processes. There are ways of conducting business that can be patented. Those are a little bit more difficult, but they still can be patented. Software is a huge area that constantly is changing. So you try to build software steps, like the algorithmic steps of a software program generally can be described, and you can get software. I did something recently on an application there was this big community housing type of application, and they wanted to be able to protect their anti-monotony algorithm, which means, you don't build the same kind of house next to someone else that looks the same and has different features and so forth. So, there are patents that you can get like that. There's so many ways of getting patents, and so many. It really does go very broadly in its reach. And I think people don't actually think about it that often. Certainly, Shark Tank thinks about it, and they always ask, is this patented? But I'll tell you another thing. A lot of times you don't hear about Shark Tank, the people who are not successful that actually do get a deal. And, there's good patents and bad patents. Not every patent is as valid as other patents. So you have to go to someone who's good, who understands what they're doing, and it has to be done correctly. It's just like making a mistake on a bad will or something. It's not any different.
And again, if you build a better mousetrap and people are happy with their current mousetrap, they're not going to go for the new mousetrap, which may be more expensive.
Well, they may not, but if you can get intellectual property protection on your idea, sometimes you can, because it's exclusionary, it works like this. You can picture concentric circles, like a circle within a circle. So if you take the outside circle as being the first one to apply, and that's the meets and bounds of their property. Okay, that's the big circle. The improvement may be a small circle within that big circle. Now, here's what happens when you have that situation. You've got an improvement patent that sits in the middle of a larger patent area. So the improvement patent does not have right to practice his improvement because he's sitting within someone else's property, a more dominant patent. On the other hand, if it's the best way of doing something, the person who owns the broader circle is not allowed to practice what's in the smaller circle, which is the best way of doing his larger idea. In that case, oftentimes there's a cross license between the two. So or sometimes just the improvement says, I will give you rights because it's the best way of doing what you have. Otherwise, you can't use my property.
And so they're usually better off by joining forces so that the original manufacturer can offer this new improved version of their product. That's
exactly right.
And now, what about in the area of medical devices and drugs? We see companies finding new uses for drugs, maybe tweaking a formula a little bit to try, because their rights are going to end on a drug and they want to keep making billions on it. Tell us about how that works and how that affects the prices we pay for drugs and how much these companies can make.
Well, yeah, life extension in the drug area is a very important thing for pharmaceutical companies, especially because they're putting millions and millions of dollars. I mean, not a few million, but hundreds of millions of dollars, right? Now, you're right. Patents have a certain lifetime, 20 years from the date of filing. And if you're eating some of that time up during the prosecution to get the patent, okay, so maybe you're left with, 17 years, sometimes less. So now you have that limited amount of time to make back your research money. So what you'd like to do is be able to extend your, the life cycle of that patent protection somehow. Now, one way of doing that is to take the drug itself and put it into a new formulation, which the formulation is now something that you might get patented. And it's a good formulation for that particular drug. So that's one way. And once a patent goes off, once a drug goes off patent, the generic companies will come in and they will produce the drug at a cheaper price. So what the pharmaceutical companies try to do is get a life cycle management in place where they can get a little bit of extension on the formula, which is the best formula. And then the doctors will say, well, this is the original manufacturer. It's the best formula because it's a sustained release and it does a better job. So that's how they attempt to do it. And the generics are trying to do something that gets a lower price. And, in the early days, the generics were done even in a garage. I mean, they there were many garage operations that's less and less now the case. There's very large generic companies out there. Some are even owned by large pharma.
Well, again, sometimes they want to dissuade competitors or buy their ideas to keep them off the market so their original drug is not diluted.
It's interesting. I had a really interesting situation with a client that came up with a method for determining where your afibrillation was coming from. Afibrillation when your heart does not beat in a normal fashion, and it's irregular, sometimes very, very fast, sometimes too slow, has severe medical problems long term. And the big issue that people had was, well, where does the AFib start in the heart? You can't figure out where it starts because there's so many cells misfiring at the same time. It's like throwing a bunch of pebbles into water and saying, you see all these waves and you're saying, well, where's the first wave? Where did that start? Well, these guys figured out a way to where that first wave started. Where was the first wrong electrical impulse for the cell? They figured that out and they sold it for an enormous amount. I did all the patent work for them. That's why I know this. An enormous amount of money. There were two doctors at University of San Diego at the time who started this company, and they came to me for help. And this large pharma company bought it, and it's an excellent company, by the way, that bought it. But because they had just purchased something else similar to it, the reason they bought it was to not put it out so that no one else would compete, and so it essentially died. Hey, can you imagine? And they paid $500 million and it died. Something close to that.
It's kind of like catch and kill, whatever that means.
Yeah.
I just want to remind the listeners listening to Daniel A. Scola, and he is the managing partner of Hoffman and Barron. As you've heard, they're a intellectual property firm in New Jersey and also on Long Island. I just want to remind you, whatever you've heard is legal information only and not intended to be legal advice. You must get legal advice concerning this area of the law or any other area from your own attorney. And you're listening to Law You Should Know on 90.3 WHPC, the voice of Nassau Community College. And if you missed any portion of this show or you want to tell someone else about it, just go to nccradio.org. Daniel, can you tell us your firm's website where listeners can find out other information about intellectual property and more information about the various areas of intellectual property you've described?
Absolutely. The website is www.hbiplaw.com. Yeah, and our firm does both the procurement of intellectual property and the enforcement of intellectual property, and it defends clients who have been alleged to be infringing. And we do both the patent area, all four areas, the trademark area, the copyright area, and the trade secrets area, and anything related to those technologies like licensing agreements and due diligence. And I'll tell you, Ken, really quickly, because I know you've got some other questions perhaps, but I just want to tell you the reason I got into this area was because my dad was a scientist, and his ideas were stolen, and he had them in the notebooks, and he went to peddle his ideas to a company, and all his notebooks were stolen during the interview, and he didn't have any patents in this area, and that's what got me interested in the area to begin with. And many people don't take the extra step to patent their ideas or to trademark their product names, or even to copyright some of the creative stuff they do. And it's too bad because it just becomes public knowledge.
And you've just demonstrated the downside of not protecting your idea. So it's great to come up with a better idea, but then in this world, you've got to protect it. Do you want to talk for one moment about fakes and deep fakes when there's some confusion about, let's say, a famous person or about a product?
Yeah, well, I can tell you that the idea of deep fakes is becoming more and more a problem because it's so, I guess if you're skilled enough, it's so easy to create these digital representations that are completely false. Now, you can detect it. There are ways to detect it. And, especially if you're going after something that is clearly disparaging or false, or somehow misusing the persona of someone or the data of someone. Those things actually are becoming more and more of a problem, and people have to be very careful about it. It's the digital area has its pros and cons, and that's one of the cons.
And things have moved more quickly, today, and people put stuff out there and share information. Just what are your final thoughts as far as protecting your ideas? Any do's and don'ts?
Well, the one thing I think most people make a mistake in this whole area is number one, they procrastinate on doing something about it. That's one thing. Number two, they talk to other people about it, and that's actually one of the worst things they can do without getting a non-disclosure agreement in place, because the laws around the world are first to file, and if you don't file before you disclose your idea, unless you're under NDA, you have a public disclosure and you're going to lose your rights. So get some kind of an agreement with someone, some kind of an agreement. It's got to be a non-disclosure agreement. It's got to be done properly. And the best thing to do is not to take a template off the website of free templates, but to get it tailored, because that will become an issue if someone raises it in litigation later on.
And of course, they can consult with someone like you to see if they have an idea worth protecting and how best to protect that idea.
Yeah, that's our business. Absolutely.
Okay, I'd like to thank our guest, Daniel A. Scholar, the managing partner at Hoffman and Barron. And as you've heard, their website is H as in help, B as in better, iplaw.com, for being our guest on Law You Should Know. If you missed any part of the program or you want to tell someone else about it, just go to nccradio.org. And remember, you need to contact a lawyer to protect your ideas. Whatever you've heard today is just presented as information only and should not be mistaken for legal advice. This is Ken Landau, and you're listening to Law You Should Know here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. And please join us next week at this same time for another program on Law You Should Know.